folks. I'm honored to be invited to come here and speak to you today. I'm going to describe three things to you. First, the lawsuit seeking an injunction against further beef checkoff funding of the NCBA. Second, I'm going to talk a little bit about the fertilizer cartel that we have sued to try to break up. This one is particularly in potash, although we've been approached by people with similar complaints in the phosphate and nitrogen fertilizer markets. And then finally, I'd like to talk to you about the investigation that we've done in terms of the purchase of live cattle by the big four packers at feedlots, and complaints that have been brought to us of an antitrust nature there. Nothing that I have to say is as important as the questions you have to ask. So feel free to raise your hand and interrupt if something that I say triggers a question. Now, of course, you're welcome to save your questions to the end, but I'll take them either at the end or during my presentation. First of all, let me tell you about a lawsuit filed late yesterday, actually, that became public record this morning. It's called Callicrate versus the U.S. Department of Agriculture. It may be called Callicrate versus Vilsack, but it is a very direct and simple lawsuit. And we've brought about 50 copies of it here. They're spread out on the table. There's some back there. It's a public record, and anyone is welcome to have a copy of it. What the lawsuit says is quite straightforward. Federal law prohibits beef checkoff funds from being used for any type of lobbying or to attempt to do political influence. Mr. Didham, excuse me. Here's a copy for you. Were you looking for one? Here you go. And you're Mr. Didmer? Good to meet you. If you have a question about the irony, I think you wrote that Mr. Stokes missed the irony. How did you put it? The irony of a large law firm like mine. I'll be happy to visit with you at any length you wish after the presentation. To go on about the lawsuit. Lawsuit's very simple. Beef checkoff dollars cannot be spent for lobbying. Beef checkoff dollars cannot be spent to influence government policy. We contend, based on public records, publicly available documents that are described in the lawsuit, that NCBA has been using beef checkoff dollars to lobby and to influence public policy. We believe this because of a 2010 audit, and the findings of that audit are laid out there. We also believe it because of public records that are described in the lawsuit from 2012, which indicate that the oversight about how they're using this money still isn't there. That the questions about how they're using this money aren't even asked. And we also put in there the facts which indicate that this organization that does massive lobbying is getting 60% plus of its budget from beef checkoff funds. And for the reasons we described in the complaint, we believe that a logical influence is that they are using those dollars for lobbying and government influence, or at least cross-subsidizing their lobbying and government influence with these checkoff dollars. We've laid out our evidence. We've explained why we believe that. The lawsuit asks for no money. The lawsuit asks for one thing, a federal injunction against the CBB, the Cattlemen's Beef Board, and the BPOC, the Beef Promotions Operating Committee, from giving any further checkoff funds to NCBA. NCBA is not a party to the lawsuit. They're not a defendant in the lawsuit. I don't know whether they will seek to intervene in the lawsuit or not. This lawsuit was brought on behalf of Mike Callicrate. It was brought in the U.S. District Court for the District of Kansas. It has been assigned to Judge Richard Rogers, although I don't know if he's a senior status judge. I don't know if he will keep the case or move it to another judge. He has the right to do either as a senior status judge. It has been assigned to a district magistrate judge that may be part of the initial proceedings in the case. It's been assigned to Magistrate Harry Sebelius. I don't know if those are the judges that will ultimately hear the case. That's a matter of judicial administration that will be decided in Topeka. We expect to because all of the defendants are United States government entities, Secretary of Agriculture, the Department of Agriculture, the Agricultural Marketing Service, the BPOC, the Beef Promotion Operating Committee, and the CBB, the Cattlemen's Beef Board, or more commonly known as the Checkoff Board. Because they are all government entities, the U.S. government has gives itself extra time to respond to the lawsuit. The lawsuit hasn't even been served yet. That takes a little while. And then the government has 60 days to respond to the lawsuit, unless they want more time, and then they can have some more time. So at some point, the government will respond to the lawsuit. At some point, we will be in front of the judge. We will ask the judge to allow us to do some discovery, look at the records, look at the numbers, and eventually there will be motions filed by one side or another. And eventually, as the motions work their way through, there could be a trial, not in front of a jury, since we're only seeking an injunction and not money damages. The trial would just be in front of a judge. And eventually a judge may hear the evidence in the case. The judge will decide whether or not to issue an injunction. We are not seeking what's called a temporary injunction or a temporary restraining order. We're simply going to allow the case to work its way through the courts and let a judge decide whether the payment of money, checkoff dollars, to the NCBA needs to be enjoined or not. That's the litigation that's on file. I'll be happy to answer any question about it from anyone. Let's see, this gentleman in the brown.
Supposing that you're entirely successful, what would the prospects be of recovery from the Cattlemen's Association of this illegally obtained funding, either by private plaintiff, or by seeking the government to go after recover the money?
Well, as I've said, this lawsuit isn't even asking for any money damages. So unfortunately, that is a question that I haven't researched and I don't know the answer to. As laid out in the complaint, and as a result of the 2010 audit, it appears that the NCBA was supposed to give back over $200,000. So obviously there must be some mechanism for that, but because that's not something we're asking for, I can't really comment on it further. It would stand to reason that if money was spent inappropriately, there must be some remedy for it, but we haven't asked for that remedy. Who else has a question? Sir, he's going to hand you a microphone. By the way, I've never been accused of having a low voice, a soft voice. Can everybody hear okay? Yep. Or is it too loud? Is it too loud now?
Yeah.
All right. I'll keep the microphone down here. Go ahead, sir.
Yeah, I'm Dave Hutchins from the state of Ohio, and I've talked to you and assisted different people. For us people in states, in the state of Ohio, we really need relief for misuse of dollars. 2 years ago, they even admitted to use checkoff funds to get a constitutional amendment when we had the CARE Board. We have a professor at Ohio State University, a land-grant college, also state-funded college, and a third of his salary is paid by beef checkoff funds. I can go on and on and on. We asked them, the Beef Board and the Ohio Cattlemen's, to join with another cattle organization state and other organizations, and we got the Attorney General plus other Attorney Generals from other state to fight the JBS venture, and they absolutely would not even talk to us. I asked to go to meetings to talk to them. I'm a member of the Ohio Cattlemen's. I pay checkoff dollars, and I was not allowed. What I'm saying is, you can see from just a few things I told you, we need relief at the state levels.
Well, let me suggest where that might come from.
Sure.
As you know, the checkoff dollars can be divided 50 cents, 50 cents, and the local boards also have access to this. I don't know what the situation in Ohio was, with the exception of some documents that you gave me yesterday, including a Freedom of Information Act request and some financial documents that I must admit I just haven't had a chance to go over. But I would encourage you that if what we're doing at the national level bears fruit, if it turns out that we're able to convince a judge that checkoff dollars are improperly being spent, then those remedies ought to be available as against any organization that has improperly spent checkoff dollars. So stay tuned, and we'll see how this lawsuit plays out. I'm going to talk about two other things. I'm going to talk about fertilizer cartels, and I'm going to talk about possible antitrust activity in the live cattle market. Does anybody have any other questions? You'll have another chance to ask me at the end. Does anybody have any other questions about the lawsuit regarding checkoff dollars? Let me turn quickly over to the idea of international fertilizer cartels. I don't know what the composition of farmers versus ranchers in this room is. I know that a number of people have an interest, have to have fertilizer as an input to their operations. We were approached back in 2008 about price fixing in the fertilizer market, specifically the potash market. As most people in this room know, fertilizers typically are composed of nitrogen, potash, and phosphate. Now, nitrogen can be produced anywhere there's natural gas and energy to produce it, but phosphate has to be mined out of ancient fossil deposits, and potash does too. Potash, as you may know, comes as an element in seawater, and it tends to only appear in commercial quantities, mineable quantities, on a few places on the earth where ancient oceans dried up. As the ocean dries up, it deposits its salt, which you can mine all over western Kansas, but the potash stays in the solution longer than ordinary salt. And so the few places in the earth that ancient oceans dried up, and the last puddle of the ancient ocean dried up, you find commercial quantities of potash. Those quantities lie almost exclusively in Canada and the former Soviet Union. There are some deposits in the United States. The upshot of this is that 6 companies, now 5, 6 at the time we filed the lawsuit, 2 in Russia, 1 in the nation of Belarus, a former Soviet republic, 2 in Canada, and 1 in the United States, collectively control over 70% of the world's potash supply. And the supply they don't control, a little bit in South America, some in Jordan, some in Israel, they tend to have ownership, partial ownership, of even those companies, like Arab Potash Company and other potash companies that control the small amount that they don't directly control. Why do we care? The price of potash had been fairly stable, $140 a ton and $200 a ton for a long, or $140 a ton or so for a long, long time. We alleged in a complaint in 2008 that an agreement was created between the Russian and Belarusian potash companies and the Canadian potash company called Potash Corporation of Saskatchewan, and a couple others, Mosaic, that was made up out of Cargill Crop Nutrition and some others, and another company called Agrium that was made up out of some U.S. companies. We allege that this cartel, that this price-fixing arrangement was responsible for shoving the worldwide price of potash up from about $140 a ton all the way up to the point that the spot prices got over $1,000 a ton. For much of this time, spot prices were at $500, $600, $700, $800 a ton. And this happened even though the inputs for potash, like the energy to run the mining equipment and the energy to transport it and refine it, those inputs hadn't gone up nearly that much. What was responsible for it? Well, if anyone wants to read the complaint or read the decisions that came out of the complaint, what was responsible for it, we allege, was this illegal agreement to raise the price of potash. We filed the case in 2008. It was vigorously defended. In 2010, in 2009, we won some motions to dismiss the case. In 2010, our victory was appealed by the other side up to the 7th Circuit. And just last month, in July, we got a decision from the 7th Circuit completely affirming what the district court did, saying that our lawsuit can go forward and saying that the allegations in our complaint were not just plausible, but in the words of the court, compelling, which is an unusually strong thing for a court to say on the remand of the case. We'll be back in front of the judge in Chicago in about 3 weeks, and we expect that case to go forward. What the implication of this is that even international cartels that are not based in the United States, that are raising the price of commodities to U.S. agriculture, can be reached by the U.S. antitrust laws. Before the 7th Circuit brought its decision back, there was some doubt about that. In fact, a lower panel, a 2-judge panel of the 7th Circuit, had ruled the opposite way. Fortunately, the 7th Circuit decision vacated and reversed that lower panel, and we can now go forward. We have had some of the same dealers in fertilizer complain to us that the same sort of thing happened in the phosphate market, and recently our phone has been ringing off the hook to the effect that it has occurred in the nitrogen market. Obviously, those are different markets. Obviously, the fact that it happened in one doesn't predict the other. But suffice to say, I'm being asked by all quarters to look into those 2 markets. Anybody in this room has any idea, any particular knowledge about that, I'd be happy to talk to you about it. I'm going to now turn over to questions about the sale of live cattle. But before I do, does anyone have any questions for me about potash or any of the other fertilizer issues? Hearing none, yes, sir.
I just want to make a comment. That, what was it, in 2008, when farmers were struggling with high potash prices?
Yes.
Anyway, I picked up a value line sheet of Mosaic. 65% owned by Cargill. Their increased earnings from the prior year were not 30% increase, not 100%, but a 395% increase in earnings from the prior year. So that tells you right there what was going on.
You'd also be interested to know that Potash Corporation of Saskatchewan, during the pendency of this litigation, turned down a $45 billion offer for itself by an Australian company. In fact, the Canadian government got in and stopped it. That's how much money they were making. If you want to see what it's like to control a scarce natural resource like potash, go out and look at Wall Street analysts' description of Potash Corporation of Saskatchewan. They boldly use the term cartel all the time, even though cartel behavior can be illegal under U.S. antitrust law. That's how the market analysts describe these potash companies. They describe, some of them describe phosphate companies in the same way. Give you another, by the way, speaking about earnings and things like that, how did we really get on to what the potash companies were doing? The Russian companies aren't used to the reach of U.S. antitrust law. They're not used to the reach of the Justice Department. So as you'll see in the complaint, if you read it, they were much more free and open about describing what they were doing, how they were colluding with the American companies. So I translated the Russian words for cartel and price fixing and all that stuff. I translated those words into Russian, even though I don't speak Russian, and ran them against Russian websites on Google. And then when I got something that was talking about cartel behavior, price fixing, I just pushed the button and translated it into English. And then when we found something that really looked good, we actually hired a Russian translator and had it translated. But that's how we got a lot of the initial evidence about this, because they were just talking about it in a very free and open manner, in a way that a U.S. company would be reluctant to. Any other questions about potash before I turn over to beef?
Just one. I mean, this is a very expensive thing to do, and I'm sure you're all up to the task. Who has financially? Who has the suit, and how do you, your group, there's a lot of business. How do you get paid, or who else will get paid? Or I'm interested kind of the economics of how, because if you don't win, or you have a client, or what, or is that beyond? I shouldn't be asking this.
I'm delighted to answer that. There have been some questions about the economics of lawsuits. One journalist even noted what he called the irony of my firm of 600 plus attorneys representing my Callicrate on this. And I guess I want to contrast the two situations. Even a firm of our size that has litigated against Walmart, it filed a case in 1999, resolved it in 2009. We litigated against General Motors, filed a case in 2003 and finished it in 2008. I just finished an 7-week-long trial, jury trial in San Francisco, California, against all the Korean, Taiwanese, and Japanese makers of LCD computer screens. It's a case we filed in 2006. We just took it to jury trial in 2012. So these things run for a long, long time. They go on forever, and they cost millions and millions of dollars to do. Even a firm of our size doesn't do these very often. We only have a small number of people, including me, that do this type of contingent work. It's all contingent. If you lose, you don't get paid. Even a firm of our size links up with a half a dozen or sometimes a couple dozen different firms from around the country that are all pursuing the same case, if in fact it's a very large antitrust case. So those are the economics of it. Our client in the potash case, for example, is a feed and seed dealer who didn't like paying could see what was being done to him and complained about it. Our client in, for example, the LCD case that we just got done trying against Toshiba, he was an electronics dealer who could see what was being done and actually had seen media reports about what was happening. He had been a client of ours for 20 years or so, and so we represented him on a pro bono basis. But neither that client cannot afford to fight Toshiba, Hitachi, Samsung, LG. No way could they afford to fight over that. And even a firm of our size tends to make alliances with other firms in order to share the costs and the risks. And one of the great truths of this is you don't always win. Sometimes you lose. Now, fortunately, in the case my law firm filed on behalf of Mike Callicrate yesterday, we don't have to worry about losing from an economic standpoint because it's free anyway. We took it pro bono. We have a committee that has to approve pro bono things, but where you had a person who's filing this case, not for economic reasons, because he can't make any money off of it, and it's being supported by nonprofit organizations who don't have any money, right? who have to scrap to get money for their conventions and stuff. It's easy to agree to do something for free, and that's what we've done. And I want to point out a young man in the back, right behind you, is a young man named Gabe Zorogastua. He is a recent has recently joined the club and become a United States citizen. He's originally from Peru, and he came up here, he got his college degree, he got his law degree. He's been a very valuable associate of ours, and he's been one of the driving forces in doing a massive research that is necessary to support the filing of a federal lawsuit. Ma'am?
Well, I just heard
He's going to give you a microphone.
I just heard in the last, I don't know, for sure 24 hours, that you must have won your lawsuit against Toshiba and all these big LCD TV makers, because they said that there would probably be a payout for all these people in the class action. Now, was that related to your lawsuit?
Yeah, let me tell you that that particular lawsuit that we filed in 06 has, there were 10 defendants, I believe. 9 of them settled. They put about $500 million, $443 million in a pool to be paid out to the people that were damaged by this. We just tried the lawsuit against Toshiba. There's a $265 million verdict, but there are post-trial motions about whether that verdict is covered by the previous $443 million in settlement, and those haven't been ruled on yet. So what happens in these situations is really complicated because under federal law, only the direct purchasers of the goods, like my electronics company client, only the direct purchasers can collect under the Sherman Antitrust Act. But 26 states have laws that allow indirect purchasers, like consumers who bought from Best Buy, to collect. Well, Best Buy is a direct purchaser, but I don't represent them. They've got their own lawsuit because they're big enough to bring their own lawsuit. So I represent a class of 200,000 and some direct purchasers who are too small to bring their own lawsuit. So it's a very complicated picture in which money flows through in different ways, depending on whether you're suing under federal law, state law, direct purchasers, indirect purchasers. And then ultimately, we have to apply to the court to award us an attorney fee. The court gets to decide. People can object to whether we get that attorney fee or not. If they object, it goes up on appeal, and it's a very, very long multi-year process. But yeah, we did win, and we did get a good-sized verdict. Other questions before I move on to the beef case? Yes. Here you go.
My question is about the role of Jamie Gamble and the HSUS in this process. Were they just collaborators up until the suit, or are they part of the suit, or what?
HSUS is not a party to the suit, and they're not lawyers of record on the suit. HSUS had brought a similar suit in California about egg checkoff, the egg board, and he alluded to part of that. So lawyers like to not have to reinvent the wheel, so they sent us their stuff, including the publicly filed order that the judge issued in that case and things. So they did everything they could to give us a leg up on our own research, but they're not actually involved in the lawsuits. Does that answer your question? Don't know.
These people, Dan, have said at your pleasure. They are there. As Nels in here?
You had to leave early.
Nels acts in D.C. If there's some use that you can make of them and their services, they're happy to be a part of this righteous cause.
All right. Let me now turn over to another issue, an issue we've been investigating for a long time. This is an investigation. It is not a lawsuit, at least not yet. We have had complaints from beef producers that they are only getting one bid at their feedlots where they go to sell their live cattle. And there have been complaints about it both in the live cattle market and the whey cattle market. And so Gabe and I and others have spent quite a bit of time talking to producers, talking to feedlots when the feedlots are willing to talk to us, and talking to others in and around the industry, including economists and others in and around the industry, some retired from the industry, about the question of whether packers are avoiding bidding against each other by divvying up the feedlots. Now, there was some academic work done on this in the 1990s. In Utah, GIPSA released a lot of data for some professors to work on, and the outcome of that published study was that during the study period, over half of the feedlots only sold their stock to one bidder, to one company, one buyer. And that most of these feedlots had a single dominant buyer. We've been told by feedlot owners that there will be equidistant packing plants, or in some cases packing plants that are even closer, that never seem to send a buyer to that feedlot. So this is something, if it proves to be true, if it proves that there is some agreement between the packers, either spoken or unspoken, to divvy up the feedlots and to not to avoid bidding against each other. The effect of this is to lower the price of live cattle. We may pursue an action on behalf of the clients, and the interested parties have talked to us about that. If anybody has any knowledge of this, if anybody wants to talk to me about it any further, my information is available here and it's publicly available. Does anybody have any questions about that? And I'm going to try to get us back on schedule by yielding the mic back to Fred. I really appreciate your time. There's a question over here.
I just want to reiterate one more time about what you said. I've been reading on the internet some of these comments and stuff that OCM and HSUS are this lawsuit. That's incorrect. Is that correct? I mean, it's by Callicrate filing a lawsuit.
Yeah, that's correct.
That's the way you stated it earlier, I think.
Yeah, the lawsuit's called Callicrate versus USDA, or Callicrate versus Vilsack.
Okay.
So, if you know, it's remarkable to me that that the reaction from NCBA was so immediate, even though they're not a party to the lawsuit. Hey, Gabe, you got that press release? It's so immediate, even though they're not a party to the lawsuit. And the lawsuit's pretty straightforward. It's not very long. It says there's a federal law against using this money for lobbying, and we think you're using it for lobbying, and here's why. You got this massive lobbying organization, you get 63% of your budget from it, and there's a 2010 audit that found that you were using it for this, at least that's the way we read it, and you had to give the money back, and then in 2013 or 2012, there's further activity, and it appears no one's even doing any oversight, not asking the right questions about how you're using the money. And so they respond that this allegation will, quote, and I quote from the news release, stifle our ability to mitigate hunger and feed people. Amazing. This is it's going to impact consumers by increasing protein costs. Now, I'm sorry. How would a reallocation of marketing dollars increase consumers' protein costs? How would it stifle our ability to feed people here and abroad? So I don't understand. It may be because I'm not sufficiently couched in the economics of the NCBA. But I don't understand those statements. Sir, anything else?
Well, I'd just like to follow it up because I have a press release from the Cattlemen's Beef Board that says OCM announces lawsuit against Checkoff. And it quotes Fred as saying, OCM and every cowboy out there owes a deep gratitude to the Humane Society of the United States of America. So in other words, Fred said, we all owe Humane Society great gratitude, deep gratitude, because they helped you up a little, because they sent you a little bit of information to help you. Okay, I just want to make sure that's correct.
I got you. All right, folks, I've had enough. Had enough. What's that? What's that?
right there.
Maybe you should find out who the PR firm is that drafted that response.
That would be it.
Might want to be
Okay. All right, well, folks, look, you know what you're up against here. I can't take on the wider question of the large corporate agricultural interests versus the smaller diversified family agriculture interests. I can't take on the wider question. I volunteered to file a lawsuit about one thing, and that's misuse of beef checkoff dollars that appears in the public record. And I'll do the best I can for Mike, Callicrate, and the other people that are hoping that this is successful. But I do appreciate your time, and if anyone has any further questions for me, you